SJC-13767, Commonwealth versus Donta L. Lewis.
Okay, Attorney Morse.
May it please the court, ADA Bryn Morris on behalf of the Commonwealth, asking this court to reverse. Under the plain language of Section 10G, crimes that occur on separate dates against different victims with charges taken out between the incidents where the cases proceed separately and they're sentenced separately are separate incidences. Resende got the right result with the right holding, but included some dicta that did not foresee other circumstances that might arise under the Armed Career Criminal Statute, like the one here. As an initial matter, even under the Armed Career Criminal Statute, a sentence need not be complete before a defendant is charged under the Armed Career Criminal Statute as a first offender, because it specifically says whoever has been convicted of a violent crime or serious drug offense would violate that provision and be an ACC1. And so the language talking about needing to have completed a sentence before a crime counting, it goes directly against the language of the statute. Further, the rule that we're asking for here is different than the federal Armed Career Criminal Statute, which, because under that statute, crimes like the crimes in Resende, where it was a series of drug transactions over a short period of time, would count as separate incidents as long as they occurred on different days. And then third, the other states' case law that was used in Resende all referred to different subsequent offender and habitual offender statutes as opposed to Armed Career Criminal Statutes. And the important point there is that a subsequent offender or habitual offender statute, unlike an Armed Career Criminal Statute, sets it up where the offenses that count as priors that would make you a subsequent offender or habitual offender are the same offenses that you're going to be charged as a habitual offender or subsequent offender. So you are expected under those statutes to go from, a subsequent offender with one offense, two offense, three offense. Whereas under the Armed Career Criminal Statute, what we're looking at is, at the moment when you possess a firearm, how violent are you? How much of a danger?
Can I ask you a question?
Yes, Your Honor.
Why do you take the position that the sequential aspects of the Resend decision is dicta, in light of the fact that the dissent in that case expressly took that on? It wasn't inadvertent side issue. It was part and parcel of the majority's reasoning as to which the dissent specifically disagreed, not because it wasn't the issue before the court, but because he thought they were wrong.
So, Your Honor, I think even though there was certainly discussion between the majority and the dissent in that case was taking a different position than we are here today. But the reason that it's dicta is precisely because the court comes up with several other statements of law that fully resolve that case. And so we're asking the court to hold that that was the holding in Resende, and that the other language, more kind of discussing the general purpose behind the statute, was not.
But wasn't that central to the rationale in Resende? Because it was cleaner in Resende than it is here, where all of the priors were resolved in a global resolution at one court case. But the feature that the court was focused on was, yeah, we have it all in this one prior prosecution, but the whole point of this is it's graduated and you need to give folks the opportunity to be rehabilitated in between. And it's cleaner in Resende because it's all done at once. Whatever the predicates were, 1, 2, 3, were all done at once. But the recidivist philosophy was the cornerstone of that. In fact, that's what Attorney Levin argued in his brief in Resende. He cited all of those out-of-court cases. Those cases were again cited in the majority. So I'm just wondering why you're saying it was dicta in that it doesn't control.
So 2 points on that, Your Honor. The first is that I think that that was dicta precisely because it doesn't actually apply to the Armed Career Criminal Statute, where it's fully reasonable under the Armed Career Criminal Statute that someone might be an ACC 3 without ever being an ACC 1 or 2, because it's just about when you get charged with a firearm, which other violent offenses or drug offenses you have. But then secondly, it's because the court presents a clear holding when it talks about crimes being brought at the same time, combined into a single set of charges, and prosecuted and handled as a single criminal prosecution and resolved by guilty pleas.
Yeah, that's what I meant by it's cleaner in
Yes.
Resende, right? But it's still, the point is they're separate incidences that haven't been separated enough in order for the recidivist philosophy to actuate, because there just hasn't been any time elapsed between what's being resolved in a global setting and the same thing here.
So, Your Honor, I don't think the recidivist philosophy is essential to the holding in Resende. I think that it's commentary that informs the subsequent offender conclusion, but I think that the conclusion that they're actually reaching when deciding the facts that are presented in Resende is far more narrow. In any event, though, the language of this, so I think whether it is dicta or not dicta determines whether this can be applied retroactively or just prospectively. But even if you determine that it was not dicta, the statute is, I would say, quite clearly different than some of the language in Resende that we're arguing is dicta. So we'd still ask that you return to the original language of the statute and apply it prospectively if that's the case.
So you're asking us to overrule Resende?
So our position is you do not need to overrule Resende in order to reach the conclusions we'd like you to draw. But if you decide that you are overruling Resende, we'd still ask that you do that.
You haven't addressed in your brief any of the stare decisis factors that would typically we would consider in deciding whether to overrule a past precedent. For example, are you arguing?
Your Honor, our position is that it's dicta and you don't need to overrule Resende.
All right, let's assume that we were to disagree about it being dictum and assume that we needed to be satisfied that stare decisis does not control. What would you argue to support an argument that we should not follow Resende, like would not be bound by stare decisis?
We'd argue that Resende, the other language in Resende is a clear departure from the statute and that it doesn't further the intent of the statute as presented by the facts here, where somebody is repeatedly committing violent offenses, getting caught and charged with violent offenses, and that is exactly the kind of behavior that the Armed Career Criminal Statute is meant to recognize, to recognize that somebody like that is far more dangerous when possessing a firearm than somebody who had committed one or no violent offenses.
Isn't stare decisis typically at its zenith on questions of statutory interpretation, precisely because it's a statute and the legislature can change it if it thinks we've understood it incorrectly?
So
your argument seems to be just stare decisis shouldn't apply because the reading was wrong. And that negates the existence of stare decisis, because if the reason for not following stare decisis is just that it's wrong, then that's not stare decisis.
You're correct, Your Honor. So in circumstances like this, where the facts of Resende are relatively like minimal criminal conduct and tied together so neatly, it's far different from the situation presented here. And I think that the legislature, when reading Resende, would understand the holding to be what we are talking about here, which just kind of goes back to my original point about this really should be treated as dicta. Because
there's a problem with that, because if you're thinking that the legislature intended to punish more harshly folks that just seemingly don't get it, then I would suggest that the legislature would look at the Resende decision and say, this doesn't really make any sense, because it would incentivize the Commonwealth to not resolve cases globally, because if you did, you would do it at really at your peril, because you could never get an ACC enhancement.
I think that, so 2 points on that, Your Honor. First, it depends on where you decide to draw the line on separate incidences. We think that the conduct involved here is clearly separate incidences because there's so many different.
Why wasn't it separate in Resende?
So in Resende, they occurred within a 17-day period.
Were they done at the same time?
Not at the exact same time, but they were one continuing course of conduct that was then charged all together and then resolved all together.
What difference does resolved altogether make?
Right.
It made a difference to the Resende court. I don't know
Not
that
the trial
it needs to make
judge.
I don't know that it needs to be a difference here. I think the more important distinction in this case is that the defendant was charged with crimes in between committing the various crimes. And so that is a clear separation from one charge to the next. That means that it cannot be a continuing course of conduct that would constitute one incidence. If there are no further questions, we'd ask that this court reverse. Thank you.
Thank you. Okay, Attorney Levin.
Good morning. May it please the court, Patrick Levin for Mr. Lewis. I'd like to begin by discussing the nature of judicial precedent because I think that
Can I just ask you a question first, Mr. Levin, to test the sequential nature of your sequentialness? Crime number one.
Yes.
Defendant's convicted of an armed robbery, sentenced to 15 to 20 years.
Okay.
Crime number two, 19 years later, he's in jail and he stabs a fellow inmate. He hasn't received the full benefit of his 20-year sentence. As you read Resende's in the law, would the stabbing would not be a separate incident for purpose of the ACCA?
No, my reading of Resende is that it would be. What the opinion says is that the prior conviction and imposition of sentence has to precede the commission of the next crime. And so the imposition, it's not that you have to serve the whole sentence.
Okay, so I was wondering what the limiting factor is.
Right. And so that's what, and that's what the court is pretty specific about that in the opinion too, that's what they say the recidivist philosophy implies, is that you've been convicted and been sentenced, and then you continue to commit crimes after that, and that shows that, I mean, and there's more than one piece of it, right? And so if it was only about rehabilitation, then it would probably make more sense to say you have to serve the whole sentence first. But there's also a retribution factor, and there's also a deterrence factor, right? And so, you know, when we think about, well, this person has just been sentenced to 15 to 20 years in prison, and they were not deterred by that at all. They went right back, they went right into prison and committed more crimes. So clearly we need, you know, that whatever the deterrence factor is, that shows that this particular person is not as prone to specific deterrence.
How does that relate to your client with respect to the imposition of probation? He had the benefit of probation on separate times.
Well, Your Honor, the predicate offenses that are alleged in this indictment, he was not sentenced for any of them prior to committing all three of them. So none of these sentences have been imposed prior to the commission of the third offense.
So that's be conviction and imposition of probation, and then he's good to go.
Yes, or I suppose the Commonwealth would be good to go.
Right, not for your purposes, but yeah.
Right.
Okay, thank you.
Does that make some of Resende's dictum then? The idea is opportunity for reflection. If it's just the day you get the sentence, I don't know. It seems like that.
Well,
I'm surprised you're cutting back a little bit here.
Well, I don't think there's any language in the court's opinion that says you have to serve the whole sentence.
No, I agree with that, but it talks about sort of an opportunity to sort of, you know, reform yourself.
Yes, and I think you would be hard pressed to find any judicial opinion that doesn't contain any dicta from an appellate court, at least a published opinion. And so, you know, if you want me to point in particular to a piece of the Resendi opinion that definitely is dicta. There's a footnote that says, we're analyzing section 10G(c), but all of this analysis applies equally under 10G(b) to a second offense, a level 2. That's clearly dicta. It's not in front of the court. But on the other hand, I think you would be hard pressed to come back into court on a ACC2 and say, well, that was dicta, so the rationale of Resendi doesn't apply to my case. You have to actually look at what the court's reason for the ruling was in order to know what the precedent is that you're bound by. Similarly, the Resendi case, Mr. Resendi's predicates were all serious drug offenses. His 5 serious drug offenses. And so you could say, well, Mr. Lewis, his predicates are all violent crimes. So the holding in Resendi, if you're going to look at it the way the Commonwealth is looking at it, the facts of Resendi didn't present this at all. So the Resendi opinion doesn't apply. And how do we know what the law might be? And the way we know what the law is we look to see what the court said was the reason that Mr. Resendi won the case. And the reason was, when we look at the structure of this statute, what's revealed is in line with a number of other statutes in various jurisdictions.
We don't know the language in those. That's the problem I have with Resendi. One of the problems is we don't know the language of the other statutes. They don't discuss it. I don't know if you've looked at it.
Well, they don't discuss it at length, but I can tell you some of them. Right. They tend to say things like someone who's been twice previously convicted. Anyone who's previously been convicted of 2 or more crimes of violence. If the defendant had been previously convicted of 2 or more felonies. These statutes do not, the plain language doesn't provide any more of a hint that this is required than in our case. In fact, less, really, because there's no separate language at all in those statutes.
Well, but the case that when you were arguing, Resendi, that you cited was the Pennsylvania case.
Yes,
and they were interpreting a prior version where this was stare decisis, because in the prior version that was deemed unconstitutional, they talked about the recidivist philosophy and how you've got to have these sequential. So they were just porting what they had said before.
So some of the decisions, they have more statutory history than our statute has, and so they analyze those. The Connecticut's decision also has some more statutory history that they look at. Some of them don't at all.
But for this purpose, though, we could go back to the Commonwealth's point of saying, hey, maybe they got it wrong in Resendi because it just says separate incidences, and whether or not, counsel said it was the same course of conduct. They were separate drug transactions to separate people on separate dates.
Well, I can tell you, I made that argument also in Resendi. I argued it was one course of conduct. The court didn't go with me on
that. Right, which is the point of the part about potentially being dictum, where the court seemingly right off the bat in the opening said, all of these were charged at the same time in one indictment and resolved in one court appearance, so that you could see that all of the other stuff about sequential and getting the opportunity for rehabilitation might seem to be dictum.
Well, I don't think so, though, because...
Well, it wasn't that case, right?
Well, but he also didn't have any violent crimes, right? And it's the same. That wasn't this case either. But that's not a meaningful distinction. And when you have to figure out, you have to look at the court's reasoning to figure out what the meaningful distinctions are. And, the Commonwealth is getting a lot of very specific provisos and claiming that it stems from the plain language of this statute. The plain language does not say any of the things that the Commonwealth says are required. All it says is arising from separate incidences. So in order for the Commonwealth to win, they need that to be unambiguous. If it's ambiguous, then this court was right in Resendi, and the rule of lenity kicks in.
You think the court could have looked at Rule 9 joinder for that type of concept?
They certainly could have, and I cited to the Rule 9 cases in the brief in that case,
right.
And that would have been a different legal rule that may or may not have led to the same outcome. I argued that it should, and the Commonwealth argued that it shouldn't.
It might in Resendi's, but I don't know about.
Well, that's what I'm saying. Is that if they had agreed with my argument in Resendi,
right,
perhaps then that would have been a totally different legal rule that would have led to the same outcome. But the answer is not, well, in that case, that's the holding of Commonwealth versus Resende, because that's not the legal rule that this court identified and applied in that case. What the court had to do is first figure out what does the statute mean, and second, apply the statute to the case in front of it.
Well, however we look at the hold in Resende, it's clear that Resende at least says that the statute's ambiguous.
What if
think
we
that is
disagree
clear.
with that?
I'm sorry?
What if we disagree with that? We think incidences is acts.
Well, I mean, in that case, you
Because
have to
the
confront-
alternative definition of frequency doesn't make sense. Or was there an argument that it did make sense?
No, I agree that it doesn't make a lot of sense.
So why would we attribute to the legislature a word, a use of a definition of the word incidences that made no sense in the context of that statute? Why wouldn't we instead say they must have meant separate acts?
So I'm going to answer that, but first I want to flag that at this point we get into the stare decisis issue.
Of course.
But the answer is because the federal statute, that's the way the federal statute works. And what the court thought was if they meant it to work the same way as the federal statute, they would have used the same language as the federal statute the way they did in the rest of Section 10G. And so that's departure from the language of the Federal Armed Career Criminal Act had to mean that the legislature wanted it to mean something different. They used different language. We need to find out why. What is the meaning that they intended? And the other departure, obviously, from the federal statute is this graduated structure. And so you have, one prior offense, you have a 3-year mandatory, 2, you have 10, and 3, you have 15. And so what is it about the prior offenses
So
that
the
justifies?
definition of incidences as acts, which is the only one that makes sense, is ambiguous because they use this wording, acts, instead of whatever the federal statute said. Is that where the ambiguity comes from?
Well, the ambiguity comes from the fact that that's not actually the definition of the word. The word really just has this rate of occurrence or frequency definition.
Oh, no,
where it
I
means-
think, unless the court got it wrong, they cite a definition that says acts, an occurrence.
So occurrence in the sense of incidents, i.e. the incidence of attacks or, the manner in which something falls upon a population. So that's the sense of occurrence that is synonymous with incidents. Incidence doesn't mean incident. That's the point.
Isn't that the key? Because it's an odd word.
Right.
Incident is, and the plural of incident is incidents, right?
Yes.
Not incidences.
And that's what Justice Cordy says, that this just means separate incidents. And what the court said is, no, we're going to look at the words they chose and try to figure out what it was they actually meant by that. And, it may or may not be true as a factual matter that this was an extremely considered decision by the drafter of this bill to use the word incidents instead of incident. Maybe they made a mistake, but that's not how the court usually thinks about these
Has
things.
the legislature had occasion to review this 10G since, 2016?
I don't think it's been amended since then, but certainly they've had occasion to notice the way that it's being construed by our courts. And, even the Commonwealth admits that the appeals court has been applying this rule in an outcome determinative way. So regardless of what whether the Commonwealth is right that reading Resende, they wouldn't have necessarily thought it was going to apply this way. They can tell how it's being applied in fact. In fact, it's being applied the way that the court said to.
Could I ask you a more basic question? So one of the things that you clearly convinced the court in Resende was that the whole point of this is that we've got to give people an opportunity to change.
Yes.
How is that, Mr. Lewis? Because if we're talking about Mr. Resende and when they do this global thing and all of these things are combined into one prosecution, this is not Mr. Lewis. Mr. Lewis kept going out and kept getting himself into trouble and kept getting probation. He kept getting probation.
So, Your Honor,
so how is this Mr. Lewis?
I'm not going to stand here and tell you that he's not a repeat offender. He has several offenses on his record. But the question is whether the indictment shows that he's under the recidivist philosophy, the question is whether the indictment shows that he's a recidivist. And what that word means is continuing to offend after conviction. That's just what the word means.
So the case hinges here that he hasn't been convicted of anything prior to the index.
And what we think is that the justification for the increased punishment is continuing to offend after being convicted and sentenced on the prior offense. And I set out in my brief the reasons why that is a justification for increased punishment under all four of the justifications for criminal punishment that we usually think about. And so, this plays into something that the Commonwealth said in their argument, which is that Mr. Resendi didn't seem like such a bad guy. That was minimal criminal conduct. And certainly that's true. And it was optically helpful to the court when it was writing its opinion. But that's not, again, a meaningful distinction between.
I don't know that it's a distinction because Mr. Resendi did all of his drug crimes when he was, how old? 19?
I believe he was 19. And he was 28 or 9 when he was picked up the gun charge.
Right.
And so, it
seemed like he learned.
Well, I'm people have all kinds of different reasons why they feel like they need to carry a gun in Brockton. But I certainly agree with you that he's continuing to offend after having been previously convicted. And keep in mind, even for a first offender, carrying a gun carries a mandatory minimum sentence. And so the question is, we think it needs more of a mandatory if you have been convicted and continue to offend, and even more if you've been convicted and continue to offend 2 times, right? That's the rationale. And so in closing, I would just say the Commonwealth has never asked this court to overrule Resendi before this oral argument. So I think that request is waived. If the court does think that this case is controlled by Resendi, that should be the end of the analysis. And I would ask you to affirm.